What's up, everybody? Welcome back into the episode of The Lawyer You Know. And today we're talking about Karen Reed again, who is trying to get her car back, her phone back, the sidebars unsealed, and we had a lawyer withdraw in this case. We're going to talk about that, whether or not it's unusual, whether it's a normal thing. What does it mean? We're going to answer all of your questions. And I'm bringing my dad back since he's up on all things Karen Reed. We're going to get his take. We're going to get his take on all of this. All right, Dad, welcome back here after a little time off, a little vacation, some much needed rest. We're back talking about Karen Reed yet again. There's been a lot of kind of comments made and thoughts about a 1983 action. So it sounds like that is going to come from Karen Reed. I don't know, but I would think the team she had, or at least part of it, would be involved in that. Alessi, Yannetti, Jackson, Little, potentially. But she has a different lawyer working on her case now, post-conviction, I guess you'll call it, since technically she was convicted of the OUI. But he's trying to handle just some normal ministerial matters that are seemingly much more difficult than they should be. So I'm going to pull up here Ted Daniels' tweet just with the document of the request that says, "Now comes Miss Reed in the above entitled matter and respectfully moves pursuant to the Superior Court Rule 61 that this honorable court order the return of all Miss Reed's personal property, included but not limited to the following items: the 2021 Lexus LX 570 and the personal cell phone of Miss Reed. As reason, therefore, counsel attempted to negotiate the return of the listed property with ADA Adam Lally in late June as property in the possession, custody, and control of the Massachusetts State Police and has not heard back. Thus, counsel is respectfully requesting this honorable court order the return of all of the aforementioned items immediately." Stephen Buzang is the new lawyer handling these issues for Karen Reed. But why don't you talk about what usually happens with the defendant's property after they're generally acquitted for most of the things as far as what the physical evidence was used for. It was not the OUI. They used this for the charges that they lost on. So how does this usually work?
Well, usually it depends. There's two kinds of seized items. There's the seized items that were put into evidence and the seized items that were not put into evidence. The ones that were not put into evidence are in control of the prosecutor. He can just, with a flip of a pen, tell the law enforcement agency, return that property, and they should do it like right away. Those items that are in evidence, those items need to have a court order to be released. However, I never objected. I don't know any prosecutor that ever objects to the court issuing a court order releasing property and evidence on a case where, they lost. And unless they have some reason to keep it, and there are some reasons to keep evidence sometimes, but 99% of the time, you just sit back, you tell the defense lawyer, hey, just file your motion. We've got no objection. And they file the motion. It's not objected to. Court signs an order. Normally, they don't even have a hearing. And the court signs an order and it's over.
This isn't even something that you need a motion and an order for, though. Like, the prosecutor could just turn over the phone in the car.
The phones weren't identified and put in evidence?
Not the phone, not her phone. Text messages, the download, things like that. But the actual physical phone itself is just in the custody control of the prosecutor. He does, and you can tell just the way the lawyer wrote the order or the motion. They could have just turned it over. He tried to negotiate it, and it's not even that Adam Lally is saying no. He's just not responding.
Which is really discourteous and really unprofessional.
Right.
I remember, if you remember, we complimented Brennan at the very end when they had the sentencing for that. I know we call it a DUI, but they call it. When they had the sentencing for that up there, we complimented him because he was a gentleman. He lost the case. He didn't scream and yell. He said, look, give her whatever a normal person would get for this type of conviction, and then let's be done with it. We don't need to continue it. We don't need to set a sentencing hearing. Let's just be done with it today. So he wanted to get everything done that day, wash his hands of it so he could withdraw, wash his hands of it, and be done with it. That's a gentlemanly thing to do. apparently the office there is not being the same way.
Yeah, and I don't know if you caught any of Adam Lally testifying in the Miles King case, but basically he doesn't really have any procedures. He doesn't document his file appropriately. It's a really lethargic way to practice law and a very kind of negligent way to practice law, in my opinion, from his perspective. And this would fall right in line with that, because either he's purposely keeping this evidence or these pieces of personal property that belong to Karen Read from her, or he just doesn't care enough to respond to defense attorneys on cases to get them wrapped up, right? This would help wrap this case up, let it be done, move it along, and he is just instead ignoring this lawyer's requests.
Well, and it reflects badly on the office, because they're public servants, and the fact that they won't return a phone call, not any citizen, anybody should be able to call that office up, and the assistant should call them back. Plus, this guy's not a rookie. He's not somebody that you're going to be teaching how to do things. This guy is a leader in the office. The other assistants junior to him look at him for an example of how to conduct themselves, and this is a bad example, and it reflects badly on the office. And maybe the criticism that office received during the Karen Read trial was definitely justified.
Yeah, and the podcast this week, I'm having a different familiar face on to talk about these specific issues about what the heck is going on with the offices there in Norfolk County in Massachusetts. So make sure everybody is subscribed and has hit that reminder bell so you don't miss this week's podcast episode. But yeah, I mean, it really is not a good sign at all. And we're going to listen to Karen Read's lawyer's comments. He went on a show, and there's just a quick 2-minute video with Ted Daniel about it. But this is the reason why people are going to run wild with speculation as to trying to figure out the reasons why they won't turn over the car and the phone, because it doesn't feel like there's any legitimate legal reason. Lally hasn't filed and explained any legitimate legal reason as to why they would not want to turn over this property. So people have started to ask the question, do you think it's possible they're trying not to turn it over because they don't want the defense to see how it was tampered with, whether it's the phone or whether it's the car? That's a question a lot of people have. What do you think?
I don't think that's the reason. I gotta be honest with you. I think it's one of two things. One is lazy, incompetent, and unprofessional. I think that's that's probably the most logical reason.
Mm-hmm.
Other reasons, and again, I haven't heard anything like this, but other reasons you don't turn evidence over is if you're going to use it in another case, or if there's an ongoing investigation that you need this evidence for, so you don't turn it over. Those are legitimate reasons. But being unprofessional and lazy and just not returning phone calls is certainly not a legitimate reason.
Yeah, and potential other criminal cases is another reason I was going to ask you about. And Karen Read's lawyer kind of mentions something else we know is going on in the background, but they've already lost by trying to take to a grand jury and returning no bill. And that's the stuff with Turtle Boy, which we'll hear about when we listen to this video. But another question people have is, do you think they're keeping it to try and help the O'Keefes in the civil wrongful death lawsuit against Karen Read?
Again, anything's possible. But even if they did that, eventually some judge, even in the civil case, is going to issue an order for that material to be turned over. So they can't hide it. It's not something that they can, keep hidden. It's not something that they can, let's hope not, they can lose. You don't lose a Lexus. So you can't hide it. You can't lose it. It's just stupid.
Yeah. My thoughts on that stuff is all the civil lawyers are going to get the entire criminal file. The case is over. It's going to be closed. All that's eventually going to get turned over, besides the things that are sealed. More on that later. But they're going to get all that information. And the physical phone itself is of no value. They did all the downloads. They have all the text messages. As long as they did everything right and they didn't miss anything, which that's why you have Burgess and all those experts who look at how to download, make sure you download it appropriate. All of that stuff's going to go to the civil case already. And if you've already done an inspection on the Lexus and you've done all the details and you've had your experts look at it, I can understand how the Lexus may be made available to the lawyers, and Karen Reed wouldn't be able to go and destroy the Lexus because everybody would have to have an opportunity on the civil side to inspect it. There'd be a spoliation of evidence issue there if she got rid of the Lexus, didn't allow these civil lawyers to inspect it. They could still use what the prosecutor did if they want to. Obviously, there's a lot of issues with the evidence and experiments and testing that they did on it. But generally speaking, the state attorney's office or the district attorney's office keeping that property is not appropriate for any of these reasons, really, except for if they truly are investigating another criminal case and they need this to investigate that. But if they are, there would need to be warrants for them to keep this. They wouldn't just be able to keep it under the guise of where she's already been acquitted.
Well, yes and no. Yeah, they could keep it even if she's been acquitted, if it's an active investigation without a warrant. They could keep it. However, law enforcement doesn't want to keep it. Again, you're saying state attorney's office, but frankly, the state attorney's office doesn't have that Lexus sitting in an office somewhere. Some law enforcement agency has that Lexus somewhere in some impound lot, and it's costing money. And it's costing them money to preserve it. It's costing them money to house it wherever it is. They have a duty to preserve it. So they don't want to keep, I've never known a law enforcement agency that wanted to keep something like a vehicle longer than they had to. They want to get rid of it to make room for other stuff. You and I have a case right now where a large boat is involved, and the law enforcement agency has the boat, and they've already given us notice. Look, you got X number of days if you want to do something, and your experiments, you have your experts look at the boat, and then we're getting rid of the boat because we don't want to house this boat. It's just, we're not equipped. It's not our job to house boats and to house cars. So they want to get rid of it.
Yeah, I disagree with some of the nuance you said early on, but whatever. We don't need to necessarily get into all that. The point being, if they're trying to keep it to try to help the O'Keefes in the civil case, that's not going to last. If they're trying to keep it because they don't want Karen Reed's team to see that they've tampered with it or damaged it, that's also not going to last, because eventually you're going to have to turn it over. And if they try to fix what they tampered with or whatever, that's going to be very obvious. So I don't think it is those things. If it is, we will find out about it later, would be my guess. But let's take a listen now to what Karen Reed's new lawyer had to say about this entire exchange here.
I'm investigative reporter Ted Daniel. 3 phones and a Lexus valued at about $60,000. State police took those items from Karen Reed. Now that her criminal case is done, she wants them back.
I put a call in to the Norfolk DA's office and inquired about getting back the personal cell phone as well as the car. When I didn't hear back after a month, it was time to, have to file a motion and let a judge order the items to be returned.
That's Steve Buzang. The Dedham-based attorney recently joined Reed's legal team. On Monday, Boston 25 reported that Buzang filed a motion or legal request to get Reed's Lexus SUV and 1 phone returned. We've since learned of a second request Buzang filed to get 2 additional phones belonging to Reed. State police took those in January 2024 while attempting to indict Reed and Aiden Carney, a.k.a. Turtle Boy, on new witness intimidation charges. As we previously reported, a grand jury blocked the indictment.
They returned no bill, meaning there was no evidence whatsoever that Karen Reed, or Aiden Kearney had committed any crimes. So I'm bewildered why those phones weren't turned back over immediately.
You've never received a rationale or response saying, hey, we're keeping them for this reason or another?
Well, I think the civil lawyers may have some interest in it. The civil lawyers can fight in another case if they want phones or cars or anything.
John O'Keefe's family has filed a wrongful death suit against Reed. That's the civil case attorney Buzang is referring to. I asked DA Michael Morrissey's office why the items haven't been returned to Reed, if there are any protocols for doing that. The response, no comment. I'm investigative reporter
Ted Daniel, they're like, no comment. It's like, yeah, no surprise there. So yeah, nothing really surprising there. Pretty much exactly what we expected and kind of how we saw the process going as well. Right? Anything to add after that?
No, it baffles me. There's really no reason for it.
Yeah. Priya said, what reasons could they have to not give her property back? We dove into that. Maybe they want the evidence to investigate the cops. Well, it wouldn't be them that would have that evidence to investigate the cops. They'd be giving it to the feds. If the feds wanted it, they'd probably already have it. Do Do you think they're just trying to stick it to Karen Reed in any way possible? I guess that is a possibility, I guess, that we didn't necessarily talk about, is like, let's ignore it just to make it miserable for her.
Yeah, that's possible. Bad form, but possible.
Very bad form.
Yeah.
I think they're all a little worried about the movie or show or whatever's coming eventually, which we know it is. Wondering if the car is drivable. It certainly should be. I mean, the damage unto it was a broken taillight. You know, wherever it happened, however it happened, whoever did it, that's the only real damage that was done to that Lexus. Peter emailed Becca, needs some help with fraud. Okay, we'll keep an eye out for that one, Michael. Papa Tragos, how much did you love your Greece trip?
Oh, absolutely loved it. I mean, it was a dream. We've all dreamed about going to Greece together. So it was a wonderful trip, and we loved every minute of it.
Yes, it was. Thank you, Captain Rhett Snuggler, for gifting 5 memberships. The next thing we're going to look at here, the motion to withdraw. Undersigned counsel moves to withdraw from the above docketed matter. Undersigned counsel's position as special prosecutor has concluded. Reports are Hank Brennan made, I don't know, $550,000+ working on this case. He has now filed this motion to withdraw. Why do you think that is?
I think that it is a standard. It's almost standard. His contract is up. The case is over, and he wants to get away from it. I don't blame him at all. I mean, I'm surprised it took him this long to file the motion because there's really no reason for him to stick around. It's over and done. His contract's up. He got his money. Amazingly, how much? If that's how much money he got, it amazes me that a state agency would pay that much, because that's about what 5 assistant.
Hold on, because I didn't know we haven't talked about that yet. So I want to take a second to talk about that. But let me just give my thought real quick. Somebody said Emily Baker said the car is undrivable due to damage done to the computer system, so the car has to be towed. Yeah, I mean, that's whatever. Well, that's a separate side issue. I don't know if that's true or not. I'll have to look at that. And of course, Kelsey just pointed out that people are laughing that it says withdraw, motion to withdraw instead of withdraw. But the real point is, if you're Hank Brennan, you don't want to be responsible for anything else that happens in this case, including turning over the cell phones in the car or anything else that might happen post-trial. If your contract's up, you want to be out, mostly so the judges don't hold you accountable. And they're like, Hank Brennan, you're still attorney of record on this case as special prosecutor. You never withdrew from this case. We never allowed you to get off. And so that's the real reason you want to file a motion to withdraw a situation like this, to get off so he's not responsible. So yeah, I didn't realize we didn't get your thought on this yet. So my opinion on it was $550,000 for a private good criminal defense attorney to handle a case like this is probably less than it would cost. But it being on the flip side, and nobody can really complain. That's between a private client and their private lawyer, what it's worth, what they're willing to pay, how good of a job they do. But on the state side, where the taxpayers are paying, where you have perfectly capable, theoretically capable, I should say, lawyers in the office that your elected district attorney hired and trained and handpicked to handle big time cases, when you have multiple of those types of lawyers in the office to go out and pay all of them and then spend an additional $550,000 on Hank Brennan. What do you think about that?
Well, I think it's absurd. I think it's absurd to have even hired Hank Brennan. If you can't handle a big case, I mean, let's face it, federal cases go on 6 months, sometimes a year. In trial, if you don't have this, if your staff is not capable of handling, how many days do we have? 27 days? How many days for the trial? Something like that. If you don't have a staff that's capable of handling that, then you don't deserve to be the state prosecutor. I mean, you don't hire guys that are good enough to try this case. You've got to go out and hire somebody else for $500,000. That's probably about 5 salaries. So you could hire 5. Let's call it 4 salaries. You can hire 4 assistant state attorneys. You can have them dedicated to this case and this case alone and try this case. It's absurd to hire somebody. Outside counsel to me is absurd generally, and to pay him this much money is absurd. I don't know how you justify it to the public.
When you were a higher up prosecutor at the state or federal level, what would you have felt if they felt like they had to bring in a special prosecutor to handle the high profile case?
You're right. I would have really been insulted.
You would not have liked it.
Would not have liked it, and it doesn't happen. At least it doesn't happen down here. And I don't think it happens in any federal jurisdiction that I know about. I know about other states. Some states do have this kind of system, but there's no federal jurisdiction anywhere in the country where they would bring in a lawyer and hire him separately. I mean, come on, you're supposed to be competent. You're supposed to be good. If you're an assistant state attorney, you should be trying 100 cases. So you certainly should know how to try a case. I don't understand. I don't understand the theory or the thinking or the amount of money.
Yeah, it's an interesting just thought. I will never say always and never, even though I just said it in that sentence as far as like where or when it happens. But yeah, it doesn't happen at a lot of the offices where, we know a lot of the higher up prosecutors that are very good lawyers, that are lifelong prosecutors, that have learned it, that have worked their way up. And most prosecutors are trying way more cases a year than we are. Now, a lot of people are former prosecutors or former public defenders, and they got a lot of trial experience there and then went out on their own as criminal defense attorneys. But as we saw with Hank Brennan, and as we know, having tried cases on both sides, it's a different mindset. It's a different preparation. We always talk about how we would love to go prosecute a case, how fun it would be. But these are guys and girls that are every single day getting up, prosecuting cases, building cases, working with law enforcement, building a rapport with the experts that the prosecutor's office uses. They should be not just equally equipped, but better equipped to handle these kinds of cases. They should have their finger on the pulse of the jurors of their community, since that's where they are trying cases over and over again. They should be equipped to handle this.
I know this is going to sound funny, but when I was an assistant state attorney, I got out of the law school. That was my first job. After a couple of years in that job and we tried cases all day in that job, and they would hand us files in the morning for cases, and that's all the prep we had. And we went down there and we tried the case. My ego was such that I believed I could try a case with anybody in the country. And you just send me down there, chief, and I'll try the case. And that was the attitude in our office. We were ready. And, I don't care who you are, our office can handle you, and our office could try a case with you.
Yeah.
And that's the way you should feel.
Like there were cases very early on where there were these like simple little misdemeanors where you'd try 2 cases in one day. I literally tried 2 cases in one day one time, picked 2 different juries in one day. They were like little nothing cases. But now if I were to think about that, I'd be like, no way I can do that. Not on any of my civil cases. I need time to prepare. I need a day to pick the jury. Like, it's very different when you're a prosecutor. And again, you go in there and the world is with you. The world is behind you. You represent the people of the state of Florida. You represent all the faces out there you're picking in the jury. It's a very different ballgame, and it's something that these prosecutors should be trained and able to do. And I think it's really funny to think about, like, I would be taken aback if I was Lally. I'd be like, I can handle this. Been a prosecutor for 20 years. We don't need this guy to come in here and do my job. I mean, it's not great. So the next motion that was filed that I wanted to talk about here is the motion to unseal the sidebars. Do you want to talk about initially why, before we look at the motion, why sidebars are sometimes or even frequently sealed?
Well, I think the best reason to seal a sidebar during a trial is so that the information, because a lot of stuff happens at sidebar that never gets into trial, never gets into evidence. It's an issue that is never raised before the jury, and you don't want something accidentally to get before a jury. He might inadvertently watch something on TV or something, and something happened at a sidebar, get on there, and it ruins your jury. You have a mistrial. You've got to start all over again. So it's to protect the integrity of the juries, not hearing things that are not evidence that they should consider. Second reason, and in this case, that's another key reason, they have both of these reasons, was to protect the identity of the jurors. And so a lot of their sidebar conversations happen during jury selection. And so do you protect the identity of who the jurors are you picked, and you protect the identity of the jurors that you excused. So you had 2 reasons in this case, both legitimate.
And in some trials, in some courtrooms, you only have sidebars for sensitive information. Like sometimes you just have your arguments out in open court. Sometimes you'll have an objection and it's a speaking objection, like a 1-word speaking objection, like objection hearsay. And you don't need to have arguments all the time at sidebar like we had in this trial. So sidebar is usually meant for some more sensitive information or inadmissible information, things like that. So you can understand why they are sealed during a lot of these cases. Let's take a read here and see what we think they should do about them now. If you guys can't see it, once again, don't worry, I'm going to read every word. Defendant Karen Reed's motion for relief from April 14, 2024, order to impound sidebar conferences. Now comes the defendant, Karen Reed, and respectfully moves this honorable court to release the transcripts of sidebar conferences that occurred prior to and during the 2 trials in this matter from the court's April 14, 2024 order of impoundment. As grounds for this motion, Ms. Reed states that good cause no longer exists for impoundment of the sidebar conferences that occurred during the first trial. See Rule 7B of the Massachusetts Uniform Rules of Impoundment Procedure. Ms. Reed further relies on the attached affidavit of counsel, which is incorporated herein by reference. Background. On April 10th, 2024, the Commonwealth filed its motion in limine for appointment of court stenographer, ongoing order to impound all sidebar conferences, and impoundment of juror names during the trial. Attached here to as Exhibit 1, the Commonwealth sought impoundment of the names of all the jurors, all sidebar discussions, including sidebar discussions during the pretrial proceedings, and that sidebar discussions and juror names be available until a verdict is returned. The Commonwealth's rationale was that the publication of matters discussed at sidebar, including juror names, information, and potentially sensitive responses to inquiry, while trial is ongoing, could prejudice the parties and expose jurors to extraneous matters. In its motion, the Commonwealth noted that after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parties of the record, except any that the court specifically finds subject to further impoundment for good cause, would then be made available to the public. Rule 7 of this Uniform Rules of Impoundment provides that a judge evaluating a motion to impound documents may enter an order of impoundment only if good cause to withhold documents from the public is shown. To determine whether good cause is shown, a judge must balance the rights of the parties based on the particular facts of each case. And this is a case citing that the decision to grant access to court documents is best left to the sound discretion of the trial court, judicial discretion, to be exercised in light of the relevant facts and circumstances of the particular case. In making the good cause determination, a judge must balance the interest of publicity and a defendant's right to a fair trial. If there is good cause to impound the documents, a judge is required to tailor the scope and of the impoundment order so that it does not exceed the need for impoundment. So you notice how they mentioned there a defendant's right to a fair trial balanced with the public's interest. And this is the defendant now asking for them to be unsealed. So I think that's important, that's pretty much how most of the cases read, is the defendant's right to the fair trial is kind of why you want to impound this in the first place. Once entered, an impoundment order remains an interlocutory order subject to continued existence of good cause. The rules say requiring orders of impoundment to be time limited. And we remember this. We read the impoundment of the juror names after trial 1. How is it appropriate? Did she give a period of time? Did she say give good cause for the period of time that she determined? Unlike other orders and judgments, an impoundment order carries no continuing presumption of validity.
Florida residents are going to be happy to hear
playing
this.
that on your.
I know.
All right. Where was I? Unlike other orders and judgments, an impoundment order carries no continuing presumption of validity to sustain it against a proper challenge subsequently brought. A party seeking the release of impounded court records does not bear the burden of demonstrating either that there has been a material change in circumstances or that whatever good cause may once have justified the impoundment no longer exists. The burden of demonstrating the existence of good cause always remains with the party urging their continued impoundment. So that means if the Commonwealth does not agree with the defense here, the burden is on the Commonwealth to explain why this information needs to be continued to be impounded versus the defense having to explain and argue why they should no longer be impounded. And that's important. The burden is always important whenever we're looking into what arguments need to be made for the outcome, for the proper outcome.
Well, again, this is just consistent with the presumption always for transparency, that if you're going to stop something from being transparent, the burden is on you, because this is a public trial and the public has a right to know. So the burden's always on the party that's trying to change basically the general rule of transparency.
All right, let's keep reading. A proper challenge to the continued validity of an impoundment order is raised whenever the party seeking to modify the order comes forward with a non-frivolous reason to do so. Once such a reason is before the court, the obligation of the motion judge is to apply the same balancing test used in determining whether to grant an impoundment order in the first instance. So that means initially when you're going to impound information like sidebars or jurors' names, you do the balancing act of the public's interest and the public's transparency and the defense's right to a fair trial. You do the same thing now, but we're dealing with very different circumstances now that the trial is over, but it's the same balancing test, and you can understand why usually they get unsealed now because it's a very different set of circumstances. And here's the argument. Because good cause no longer exists for the order of impoundment to be continued with respect to the sidebar conferences, and because access to those materials is required for trial preparation, the impounded materials should be released at a minimum to the parties. The order of impoundment related to the sidebar conferences was entered by agreement on April 14, 2024. On November 13, 2024, the court further ordered that certain transcripts of the sidebar conference be provided to counsel and the court. The court issued a separate order of impoundment on the list of jurors, the second trial on June 18th. Hold on one second here. On June 18, 2025, and extended that order on June 26, 2025. Order to extend the June 18, 2025 impoundment order. In accordance with these orders, the identities of the deliberating jurors in both trials in this matter remain impounded. That aspect, the identities of the jurors of the Commonwealth's April 10, 2024 motion remains unchallenged here, as the issue of juror identities was subsequently addressed by the court. Ms. Reed instead seeks only the release of sidebar discussions that took place during the trial, and those that addressed evidentiary rulings prior to trial, because the good cause the court recognized when impounding such conversations no longer exists now that a verdict has been rendered. Originally, the Commonwealth was concerned with the release of the sidebar conference transcripts during the pendency of the first or presumably second trial could expose jurors to extraneous matters. However, now that the trial has concluded, that issue is moot. See Exhibit 1. As the Commonwealth noted in its motion, after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parties of record, except any that the court specifically finds subject to further impoundment for good cause, would then be made available to the public. The court has found that the identities of the jurors should remain impounded until and unless otherwise ordered by the court. With regard to the sidebar conversations, however, good cause no longer exists for impoundment. Such discussions should now be part of the public record. So first, let me ask you a question. What do you think about the juror names continuing to be impounded? That's not kind of the main point of this motion, but what are your thoughts on that in a high-profile case like this with obviously very strong opinions?
I've got no problem with it. And honestly, the defense really doesn't have a good argument for why the jury's name should be released. I mean, there really isn't a good argument for that. I mean, whose benefit, why? I can understand why the sidebars might be released. They may have some benefit in future trials or something, civil cases, but there's no reason to release the jurors' names. They have no evidentiary value. They have no future value. So I don't have any problem with that staying secret.
Yeah,
but I got to tell you, I bet you at some point there comes a time when they are released, even if it's not now.
Yeah, I think there'll be a motion that they want to release them, but I'm okay with it being the juror's decision. You know, in a case like this, if they want to come out and say I was a juror and, you know, here's my name, then they can. But it's kind of a similar thought process where I think one of the biggest reasons to release the sidebars is the public interest. The public should know this public information to see how the judge was making a decision, how their state prosecutors that they are paying their salary, what arguments are they making, what was happening back there. That is the public interest. That is part of the process in the trial that the public is subjected to with all of these people involved. They should be able to see and read it. Whether you think they're nosy or, you know, they're just going to, you know, do something wrong with it or whatever, that's the whole point of transparency in this public process that our country is founded on.
Right. What would people think if they closed the doors to the trial,
right,
and we had the Karen Reed trial in secret, and you know, no one knew what the evidence was, no one knew what the testimony was. All you knew was the verdict when it was over. No one.
And that's the point. And this stuff that may have been inadmissible or irrelevant to the trial as decided by the judge doesn't mean it was all something that at least some lawyer wanted to bring up at some point, and that's all something that the public has an interest in. Alert One system says, is Aperture still enjoying the Commonwealth's new Lexus? Well, maybe the Commonwealth's, but shouldn't be Karen Reed's. I heard other prosecutors wouldn't take the case. I don't think that's true because McLaughlin and Lally still worked on it the entire second time. So I don't think that's true that none of them would take it. All right, yeah, I'm going to wait for those. Peter and Papa T, I took the bar yesterday and I'm enjoying getting caught up on your videos today. What a nightmare test. How did you feel after the bar? It is a nightmare. It was my worst part. It was what I hated the most out of the whole process, probably because I graduated, bought my first house, had my first kid, and moved and started my job here all literally during that same summer. So it was very brutal for me. I was pretty confident when I left, though. I did every single study question, every single practice exam, every single lecture, every single thing. Barbary was the course that I took. Everything that they offered, I did. So as miserable as it was for 2 days, it was hard to sleep. I wanted to get it over with, but I was pretty confident when I left. What about you?
I was not. When I left the bar exam, what happens when you leave the bar exam, I'm sure it happened to him, I'm sure it happened to you. Everybody starts talking after you leave. Well, what'd you get for this answer? What'd you get for that answer? And all my friends, we were all talking, and I'm going, oh my gosh, I missed that. Whoops, I missed that point. Oh no, I didn't write. I was not confident. I thank God I passed. But I tell you what, I wasn't confident when I left the bar exam.
Yeah, well, we did not talk about a single question, like multiple choice. We did talk some about like what the exam topics were, because in Florida, they pick a couple topics. You don't know what they're going to pick. So you have to study for all of them. And there was a kid next to me. This is the only thing that freaked me out. There was a kid next to me who literally, when we started doing the essay portion, we opened it up. He flipped through the pages to read what the topics were. He closed the book and walked out. And I was like, and if you've never seen a picture of what the bar exam at least looks like in Florida, it is like mental warfare. It's like hazing. It's crazy what it looks like. Okay, let's get back to the motion. The court has found that the identities of the jury, I already read that. In balancing the public's right to inspect documents against a defendant's right guaranteed by the Sixth Amendment to a fair trial, a court may consider a variety of factors. These may include whether the information has already been disclosed, the nature of the documents under impoundment, or whether there are alternatives to withholding public access, such as a change of venue. There are, at this juncture, few aspects of this case that have not been explored in high-depth publicity. Ain't that the truth? In fact, in its determination to continue the order of impoundment regarding juror identities, the court noted that this case has garnered significant and divisive attention in Massachusetts across the nation. In other words, virtually every issue in this case, especially following a completed trial, has already been disclosed. This factor weighs in favor of ending the previous order of impoundment. So even though the burden is not on them to prove that this should be unsealed, they're still going to make the argument. Another factor, the nature of the documents under impoundment, also weighs in favor of their disclosure. As noted, Ms. Reed herein seeks only release of sidebar conferences, not the identities of the jurors subject to the previous orders. To the extent deliberating jurors could have been exposed to the extraneous information, the Commonwealth referenced in its April 10, 2024 motion, that concern ended with the juror's service and the second trial. Additionally, there are few, if any, privacy interests implicated by evidentiary discussions at sidebar. See Rule 7B of the Massachusetts Uniform Rules of Impoundment Procedure, and then they cite some cases. The extent of the community interest also weighs in favor of the release of the sidebar conferences from the order of impoundment, even while acknowledging the court's duty to minimize the effect of prejudicial pretrial publicity. Though Ms. Reed does not bear the burden of establishing the good cause, that good cause no longer exists for the order of impoundment to remain in effect and need not establish a material change in circumstances. It is apparent that any good cause that did exist during the trial for the order impounding sidebar conversations is no longer present. The factors the court must consider in determining whether to continue its previous order of impoundment all instead suggest that the referenced sidebar conferences should now be part of the public record of these proceedings. The conclusion. For these reasons, Ms. Reed respectfully requests that the court release any sidebar conferences that occurred during either of the two trials in this case, and any pretrial sidebar conferences dealing with evidentiary issues from its prior order of impoundment, except as to the identity of jurors. Ms. Reed also respectfully requests that the court allow this motion administratively without a hearing. So what are your thoughts? What do you think is going to happen?
Well, I think the judge is going to release the sidebars, but something you know when you read this motion, and again, it's sad, and it just kind of shows you that there's still such animosity. Normally, you call the prosecutor's office up and ask them if they have an objection to your motion. That's what you do. Prosecutors say, yes, I object. No, I don't object. So that you can put it in here so that the judge doesn't have to sit here and have some big hearing and block off an hour of time for unopposed motion. But obviously, there's no communication here between the defense and the prosecutors, and it's sad that that's the way things are up there. I don't know if it's this case or every case. I don't know how that office operates, but in this case, it really is sad that the prosecutors just can't get over it. I mean, they lost. Move on. You got 1,000 other cases. So that's what I know is when I read this is that there's no indication that there is or is not an objection. But I do think the judge is going to release the sidebar. At least the judge should release the sidebar. We've done this before. What the judge should do and what the judge does do may be two different things.
Yeah, I don't think it's just this case. And that's kind of the topic of the podcast on Monday is there's a King case, there's the Walsh case, Birchmore case, Reed case, so many other cases in Massachusetts where prosecutors just aren't responding, not doing their job, not turning over search warrants, not turning over evidence, missing major evidence and huge pieces of evidence in the case. I don't think this is a one-off, unfortunately, for this DA's office. And I just think it feels like par for the course, that this is not an unopposed motion or a joint motion, because again, win or lose, you're a prosecutor, whatever, this stuff should be public. Go ahead and let it be public and join their motion. Now, there is a caveat, and it depends, like there commonly is for lawyers. We are going to read the lawyer's affidavit in a second, but and I can see them parsing out potentially, maybe drafting or having them typed up by a stenographer, the sidebars, and seeing if there are portions that may be redacted. If you talk about a minor, because there were some minors that were witnesses or potential witnesses in these two trials. If you talk about juror names like we discussed, if you talked about something that was related to the FBI investigation, that there is some kind of protective order or some kind of confidentiality around, you can redact that piecemeal and on a sidebar by sidebar basis. But the vast majority of these should be released, should be public, should add to the transparency, and the people that want to look at them should be able to.
Well, again, another thing too is that the lawyers should be able to get together and make some decisions. Yeah, okay, we don't need that. Yeah, we do need that. Yeah, you can redact that. That's the way it's done in 90% of the country. I tell you, the reason it's not done in Boston is for two reasons. One is the electorate elected this state attorney or district attorney up there, so they have a responsibility. They elected this guy. But the other is the court. Judges have authority and they have power. If they would exercise that power, then maybe they could teach a lesson to these prosecutors, right, so that they would start becoming gentlemanly and would be professional so that they can deal with these things. And hopefully I'm not being sexist when I say gentlemanly, I mean the ladies as well, so that they can be professional as prosecutors, and the judges don't have to waste time. Like, this would be a waste of time. If that judge has to sit here and go through every sentence of those sidebars rather than the lawyers getting together and doing it, think how much court time is going to be wasted.
Yeah, Ashley asked a good question. I don't know the answer to this in Massachusetts. Question, Peter, Bev would still rule on this? I heard she was out and on the civil bench now. So if she is, I don't think she would still be handling these matters, would she? I don't know the answer.
I don't know, because again, we're talking Massachusetts, so I don't know how they do it.
Yeah, here it would be whoever took over this docket,
Right.
the criminal judge would handle this. It wouldn't be, if somebody's in civil, they've got their own civil caseload now.
Right.
Yeah, especially for things like this. You don't need any specialized knowledge about this case to answer any of these questions. All right, let's read through. Let's answer a couple more questions here before we read the affidavit. Just Jenny, in Massachusetts, this case was intensely debated. This is our local system. We are a very blue-collar state who support our police proudly. Relieved she was found not guilty. I'm surprised it wasn't thrown out. Thanks for helping us sort through it. And I think Jenny's main point is that the public is very, very, very interested in this. There are a lot of people. They could unseal sidebars in 99% of cases in America, and nobody would ever read one word of it, unless you're doing the criminal appeal, I should say. But this is not that case. And the more public interest, sometimes it feels like the more public interest, the more judges want to gag stuff and seal stuff. That's not how it should be. The more public interest, the more that weighs in the transparency that people want to know about this. Now, it can also add to people doing bad things to jurors or witnesses, and you have to include those protections. But generally speaking, more public interest means more transparency.
I think you can predict, predict, because we saw the trial, we watched this trial. The sidebars are going to be more damaging to the prosecutors than they are going to be to the defense. I definitely think that a lot of evidence was kept out by the prosecution that is now going to become public, that the prosecutors tried to prevent things from happening or tried to prevent people from saying things. That's going to now be public. So I do think it's going to be a bad public relations release for the prosecutors.
I don't know how much worse it can get for them, but I will say it's one of those things like what you're willing to say in public, just imagine what they're willing to say in private kind of thing. I mean, right. Hank Brennan should know that all this eventually was going to become public. So I don't think that he just was going off the handle like Proctor's private text messages, but I do think you're right. I think they probably stretched and reached a little bit more in sidebar than they did in front of the cameras, but that's just a guess. So if the car isn't drivable now, who's liable to fix it since the state messed it up?
Nope. Tough break for Karen Reed.
Yeah. As long as they didn't, purposely do it or, right. Do it just to hurt her or mess with her, as long as it's part of legitimate testing, which is probably going to feel like it will, or come down that was, if it really is undrivable, that's probably how it's going to end up, which sucks. So funny about the bar.
I can tell you.
Go ahead.
I was just going to tell you a story. When I was a young prosecutor, back then we had a lot of fun. We used to go riding with the cops on search warrants. We would write the search warrants and we'd get in the cop cars and we go, and they would literally, again, we were punks. They would literally let us kick the doors in as we went in, and we did all that. And then we took sledgehammers to the walls if we believed they were hiding the dope in the walls and stuff. And then we would leave the house and there'd be holes in the walls from the sledgehammers. The doors would be kicked in. And then they'd call and they say, well, who's going to fix this? And the answer was, not us. We were executing a search warrant.
Yeah, it was a different time. It was a
different time.
Yeah, and I'm glad those times are gone. Next vacay, you got to come to Smith Mountain Lake, Virginia. Never been there.
Good.
So funny about the bar exam. My husband took it this week and texts were flying as soon as everyone could get their phones back. You know what's funny? I had so many different people message me about taking the bar exam. It's so funny how many lawyers and law students watch the channel or follow us on social media and reached out. We need to do something about that next year, like talk about it leading up to it more, because it's just so interesting to me, all the different people that took the bar exam. And I actually popped up on my Facebook feed from 12 years ago or whatever when I took the bar exam of a note Whitney wrote me that I read like in the morning on my way out to take the bar exam. So it's kind of cool, nostalgic to look at. If I had to take it straight to a junkyard, I'd want it back. Wouldn't want them to have anything of mine. Oh yeah. I mean, that's how most defendants think. It's like, it has nothing to do with anything as far as value of it. It's like, that's mine, give it back. You should have never had it. Peter and Papa T. I've never been called for jury duty. Would love to. Do jurors get to hear sidebars? No, that's the point of doing it at sidebar, so that the jury can't hear it. Some court systems have like white noise machines. There's usually a bailiff standing between the sidebar and the jury to make sure the jury can't hear it. And if the bailiff can hear what you're talking about, I happen to be loud. Sometimes the bailiff will be like, we can hear you. And so we'll have to tone it down a little bit at sidebar. Anything to add to that, Dad?
No, you're right. No.
I want to hear the sidebar discussions about not allowing Michael Easter. I mean, my guess is if they came out, there's so many different things that you're going to want to read as to what happened on this in this sidebar. Brianna, what's more stressful, the LSAT or the bar exam? Bar exam, not close at all. The LSAT, you can take multiple times. You're in high school. You're like a dumb 17-year-old kid. I was like, whatever. Yeah, I practiced for it. I think I took it 2 or 3 times. I didn't even care. I was just going to keep taking it until I felt like it was a good enough score. The LSAT to me was so easy and short. The bar exam is brutal. Would you agree?
Oh no, the bar exam is a test of endurance. Realize it's multiple days, so it's a test of endurance.
It's brutal.
And you can't sleep. I mean, you try to sleep the day between the 2 days, and you really can't sleep because you got 800 things going through your mind, and you're hoping you don't forget anything.
And it's not even like an adrenaline rush and come down after the first day because you know you got to get up and do it all over again. 1.7K likes, 7.3K watching. We can do better. Yeah, everybody hit that like button. Hit it here. We're going to read now the affidavit. Whoops. Affidavit of counsel in support of the defendant Karen Reed's motion for relief from the April 10th, 2024 order to impound the sidebar conference. I, Damon M. Seligson, do hereby depose and state that the following is true to the best of my knowledge and belief. I'm an attorney licensed to practice in Massachusetts. I represent the defendant Karen Reed in connection with the above captioned matter. I've reviewed the Commonwealth's April 10, 24 motion in limine for appointment of court stenographer, ongoing order to impound all sidebar conferences, and impoundment of juror names during trial, which was allowed by agreement on April 14th, 24. I have also reviewed the court's November 13th order regarding the sidebar conferences. I have also reviewed the June 27th order to extend the June 18th impoundment order. The court has found that the identities of the jurors should remain impounded until and unless otherwise ordered by the court. The defense is not contesting that separate order of impoundment, nor that aspect of the Commonwealth's April 10, 24 motion in this motion for relief from impoundment. Pursuant to the court's allowance of the Commonwealth's motion on April 14th, sidebar conferences remain impounded, though it is not the defendant's burden to establish good cause or a change in circumstances justifying the release of documents from an order of impoundment. I nevertheless believe that there is in fact good cause to release the sidebar conferences. Primarily, a verdict has now been rendered in this case after the second trial, and there is no longer concern that public dissemination of sidebar discussions could prejudice the jury pool. I also believe that the verdict constitutes a material change in circumstances justifying modification of the court's prior impoundment order relating to sidebar conferences. In reviewing the case law surrounding relief from orders of impoundment, as discussed in the attached motion, I believe that the factors the court must consider weigh in favor of releasing sidebar conferences from the order of impoundment. For these reasons and those explored in the attached motion, I believe it is in the interest of justice for the court to allow this motion. It's so wild to me that they have to do this with every motion, have this affidavit. And it's kind of interesting when you see the lawyers doing it and what it actually is. And then you notice that Hank Brennan purposely decided not to do it a few times. It's kind of interesting, right?
No, I don't understand the reason for it.
It's like so that you prove your good faith basis as a lawyer, and you can be held accountable if you're lying under oath and emotion, which you already can. Like if you lie to a court, there are plenty of protections in place to hammer you. But
right, you can be in Florida. You can be if you file a motion, forget the affidavit part. If you file a motion, you lie, you can be disbarred. I mean, they don't trust their lawyers in Massachusetts, I guess. I mean, they don't.
It is weird. It is weird. Somebody just asked a question here. I wanted to. I don't know. All right. So here's a question that I was not prepared for and didn't ask you about. So I don't know how much you've looked into it. I have seen it, but I don't know anything really about it. What do you all think about the 100 cases that were dropped recently because they don't have enough attorneys? I don't know if you saw that.
I did.
And then this, I think, is another comment on it. The court-appointed lawyers are in a work stoppage because they're only getting $65 an hour. Meanwhile, the state pays Brennan $566,000, dismissed over 100 cases without prejudice, no lawyer. So have you seen those articles and statements?
Yes, I have. They're happening all over the country where they run out of money for appointed lawyers, and therefore they don't have enough lawyers. Some states are saying it's not unconstitutional. Apparently, I don't know. Did that happen in Massachusetts? The 100?
I don't know.
I don't know what state. I read the article and I don't remember. I don't remember what state it was, but I remember reading the article because it always fascinates me. I mean, these people did get arrested. They may or may not have committed the crime, but the courts are letting them go just because they don't have enough lawyers. And that happens. It happens all over the country. By the way, it's not unusual. Florida's the same way. In Florida, we pay ridiculously low amounts of money. In Florida, if you do a murder case in Florida, I think the pay is $2,500 to $5,000 for an appointed lawyer to represent someone in a murder case. That's an absurd amount of money for a murder case.
Yeah,
for an end of life case. And
even public defenders, they don't make enough money. They're
they don't.
paid and overworked. I mean, it's really, really brutal how that entire system is set up. And it's like people still accept those jobs. There are some very good public defenders. I'm not saying that they're all bad, but there are a lot of bad public defenders that keep that job because it's the only job that they can get, or very young public defenders where you come in and that's where you start and that's where you cut your teeth, which can be great. But if they're always siphoning out and it's always only young lawyers, you can understand why people think the system is set up where if you have money, you've got a shot. If you don't have money, you've got no shot. This is kind of a culmination of what we've talked about so many times in these different cases.
Right. In some states, the Association of Criminal Defense Lawyers in those states are actually organizing the lawyers to not take cases until they raise the fees, so that there's nobody available to take the cases, and they're backlog and big log jams in the court system. Because think about it, the court system cannot function without lawyers that are going to be representing defendants. So it's just shutting down the court systems.
Yeah, and because of the Constitution, and they have to be there. And if they're not, it creates scenarios where legally they do have to be dismissed. And that's really scary and sad for the community and the area. I mean, public defenders make less than a lot of cops. They make less than some teachers, even at some schools. And this is after going to law school, racking up a ton of debt, some of them. And some of them stay for 10 years to get it waived in certain states that do that. Because if you work for the government for X amount of time, they might waive your student loans. So there's just all sorts of things going on in the background. None of it is really great. AB said, yes, it did happen in Boston, Massachusetts.
Okay.
Yeah, I mean, it really sucks. It really sucks. It's not how it should be. But it's one of those problems that any which way you look at it, if you think you solve one thing, you create another problem.
But it's not a popular item, because if you go to the general public and say, hey, look, we want to raise taxes so that we can pay lawyers to represent people who have committed crimes.
Who just don't have the money to pay for it themselves. We want you, Miss Victim, to pay for the lawyer of the person that committed the crime against you because you're a taxpayer and they don't have any money for a lawyer.
It's not a real popular selling point.
Right.
Yeah.
But it's important. We all know, everybody following this channel, everybody in this community knows how important it is and how very quickly and easily it could affect someone you know or love or yourself, and how often people are wrongfully accused. And it can happen, and you need a lawyer to help prove that. So, I mean, it's tough. It is tough. I'm behind, but tell your dad that when he did the call with you from his home office on Karen Reed verdict day, I seriously thought it was a green screen background of a jail cell. I thought he did it like Karen was going to jail. Yep, that's pretty much what we felt about his home office growing up. None of us ever wanted to go in there. And you all know why, because you got to see a little peek into it during the verdict watch with Karen Reed. That was hilarious. So it's happening in Massachusetts where Hank Brennan is literally getting $500,000 to work for the state. I mean, that is frustrating, where it's like, whatever. We're getting on the hour mark. I think we've hit it enough. Anything else you want to say about the cars, the sidebars, the telephone, anything else?
Just think how much time and money the court system's wasting up there on this when they don't have to. I mean, it's a stroke of a pen by a prosecutor if he would, just pick up the phone. It's just a real shame. It is. Yep. As a taxpayer, I'm offended.
Yes. I would be so frustrated with the whole Karen Reed, Turtle Boy, trying to get indictments there and failing, already dropping some of the cases they were prosecuting him on. I mean, the whole thing is just, it feels like such a waste of judicial resources and time. But all right. Hopefully you guys enjoyed that episode. Hit the like button, please, if you have not already, and make sure you're subscribed. If you are interested in this topic, I am 100% positive you will be interested in the topic that we talk about on Monday's podcast episode. Keep an eye out this weekend for the teaser. And make sure to let me know what you think and what other cases you're following. Adelson trial starting in a couple weeks. That's what our main focus is. But we're also taking a look at a couple different cases that you guys have seen. So until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.